Lordship, this I is for condemnation of delay, Your Lordship. Notice may be issued.
How many days? First time listed.
31 days, Your Lordship.
First time listed.
Lordship.
Heart censure, learned counsel for the petitioner. The present application is filed for condonation of 31 days delay in filing the connected writ appeal against the impugned judgment and order dated 11/6/2024, passed in WPC number 376 within bracket AP 2024. Full stop. Issue notice returnable after 4 weeks. Full stop. Petitioner to take steps for issuance of notice upon the respondents within 5 days from today. Full stop. Steps be taken by registered post AD as well as through usual process. Full stop. List accordingly.
Obliged.
No. Anyway,
Lordship, this is PIL. This
why
challenge,
PIL?
Lordship, this constitutional validity is void ab initio. Lordship.
I understand. Constitutional validity is challenged of an act, no doubt, no problem on that. But while public interest, you can yourself be an aggrieved party.
Yeah,
No, this law is in violation of constitutional provision, these, that, those limited grounds.
Lordship, in this regard, that regarding challenging of the act, there has been one
What
clear-
are your grounds of challenge?
Your Honor, repugnancy, this is inconsistency with
Repugnancy with?
Central Act, Your Honor.
Okay.
And then violation of fundamental right, that it is collide between directive principle of state policy and fundamental right. On that ground, state legislative has to take a set of precedent. There is no any essence of just taking.
Yes, Mr. Advocate General, it will need some in-depth hearing.
Firstly, whether the petition is at all maintainable.
No, PIL we have doubt, but still it's for hearing.
There is a clear judgment now of the Supreme Court which says that by way of a PIL,
That's why the
challenge to a statute should not be entered.
statute should not be entered.
So that is number one. And number two, there are so many other. It is the pleaded case of the petitioner himself that at paragraph 28, that 40 people were detained under this act. There is no statement as to why these 40 people did not challenge and how is it that he is prejudiced.
Who is he? This
Who is he? Exactly. That
Who
is
is
the
this
question.
petitioner?
Yes, Lordship, when there is a violation of the fundamental rights, Lordship, that
No,
one,
there is no problem on you, the petitioner challenging the provision of the act. But it should be a writ petition challenging and statute on certain limited grounds, repugnancy, violation of article, legislative incompetence. Fundamentally, these are the three. And there are some addition recently which are ultimately relatable to this provision.
exactly, Lordship.
And the most important question, if your lordship sees the prayer,
Why don't you restructure this?
Lordship,
There might be you might have a case we do not know.
your lordship will kindly see the prayer that the act as a whole has been put to challenge. There is no specific provision that is under challenge. The act as a whole is challenged. So the moment we show legislative competence, the challenge itself falls.
Lordship, in due course of the submission, that it will arise, Lordship.
No, that we understand. See, first answer the first objection by the advocate.
Yes, Lordship, regarding challenging the act, there has been one FIAL, Assam Parliamentary Secretary Act 2014 was struck down in FIAL, Lordship.
Hmm.
It was, he was not a parliament secretary, but just he was simple citizen.
No, we are not disputing the locus of this petitioner to challenge a statute. There is no doubt about that.
Lordship,
You can challenge, it may not be directly aggrieved party, you may not have any involvement, any apprehension on arrest under this act, but you can file. There is no doubt about this.
Lordship.
Why PIL?
Lordship, may I come to, in my
Where
rejoinder,
is that recent? There is.
I will lay down.
Hmm.
At paragraph 50,
Hmm.
I'll place the judgment. It is only in extremely rare circumstances that the Supreme Court has said that normally your lordships will not entertain any PIL.
Now what are you doing? We are going for final disposal today or what?
Lordship,
Are you ready?
yes, Lordship, I am ready for hearing.
Yes, Advocate General.
May I just,
Lordship, by this act, there has been one case that even underage has been detained without producing before the magistrate court. Whereas it should have been produced before the magistrate court within the 24 hours. But there is, Your Honor, this is judgment order of the, Your Honor,
Issues are important. So what to do? I don't even think the problem is that when you deliver the letter. Again, 16 minutes. How much time will you take? See, there are some time constraint.
Lordship,
This is a judgment, this will be a case either, this is a hearing matter. Ultimately, it is fixed for hearing. Whether we take the first point of maintainability or we enter into the merit, it will need some deliberation.
Lordship,
And then we'll have to pass a judgment, which will not be possible. Tomorrow is a holiday, then 16, both of us will not be here.
Lordship, minimum I will say 2 hours, Lordship.
You will take 2 hours.
Yes, Lordship.
And if you take 2 hours, we must reserve for him for 2 hours. And there is a single bench. Will it be possible today? Then it will be CAV. If you argue 2 hours, at least we need to write the judgment for 2 hours. Isn't it?
Lordship,
2 to 6.
Lordship, on that case, on 16, for particular this case, maybe fixed on 16, Lordship, on that case.
16, day after tomorrow.
Yeah.
Tomorrow, I'll get it.
19th. AZ is here.
19th, I'm,
We'll detain AZ.
in that case,
We
my
may
lord,
leave, we'll detain AZ.
in that case, my lord, 22nd, I have to be back here. Let me be.
22nd. Okay? 22nd,
That's it.
agreed?
I'll just leave, sorry.
Otherwise, we can, therefore, we have asked how much time will you take? 2 hours, 2 hours, 4 hours.
I
Then
can understand.
this bench is next week not available. And then you will have to deliver the judgment sitting in Guwahati, but that is also not a problem.
Today
Then
also,
also,
On 22nd, I am coming back for another case anyway.
okay.
So,
Lordship, if
As agreed to by the learned council for the parties, list this matter on 22nd. For hearing. You also be ready with that point first,
Lordship,
whether it's maintainable or not. If we think that it is an exceptional case, maintainable, we will proceed.
and let's most probably, even in Land Reform Act and this preventive law, that assent of the president is mandatory.
No,
Lordship.
that we are not on ground. You might have 100 good times. This may be a case of striking down the legislation. That is a different aspect. But whether as a PIL, if you said pass that hurdle, then we'll go for merit. That's all.
again, otherwise, on the point of repugnancy, your lordship will not find any specific pleadings that this provision is repugnant to so-and-so provision of a central act.
No,
So in that case, even the question of 254 does not come because on 254 Supreme Court is very clear that the burden is on the petitioner to show it is repugnant to which provision of which central.
Lordship, fear of the detention is very much. When
Okay,
it is
then we'll-
illegal,
then
that
we'll
entire
hear
act
it.
is.
22nd. For the reasons recorded herein above, this court is having no hesitation that the assessment of the petitioner's property needs to be made and compensation is required to be paid on the basis of the notice from the date of notice dated 24/5/2022, and such assessment is to be made in terms of office memorandum dated 03/06/2021. Accordingly, it is directed that petitioners be paid compensation in terms of reassessment made / to be made in terms of office memorandum dated 3/6/2021. Such payment be made within 8 weeks from date on which a certified copy of this order is submitted before the Deputy Commissioner, Simomi District by the petitioner. If such payment is not made within such period, the same shall carry an interest at the rate of ₹6% per annum on the compensation already assessed / would be assessed till its payment. With the determination made herein above, the petition stands allowed to the extent as indicated herein above. It is further made clear that till such payments are made, the possession of the petitioner shall not be disturbed.
Much obliged.
Yes.
My lord, I beg to
Keep it in
mention
the
item
chamber.
number 8, my lord.
Chamber. There are some corrections. Yes.
Item number 8, my lord.
Item number?
8, my lord. My lord, here, my lord, I have received, my lord, counter affidavit filed by respondent number 4, my lord.
Uh-huh.
My lord, here, respondent number.
You are
4
responding for? Yes.
My lord, respondent 4 has filed counter affidavit. My lord.
Ah.
My lord, I need some time to obtain instruction from my client. My lord.
You are Mr.
L. Nosi, my lord.
L.
Nosi.
Nosi, Ligam Nosi. Learned counsel for the petitioner submits that an affidavit in reply has been filed by the respondent number
4, my lord.
by an affidavit in opposition has been filed by the respondent number 4, and accordingly the petitioner needs to reply to the same. Full stop. In view of the aforesaid, he prays for an adjournment. Full stop. Adjournment is not opposed by Mr. D. Senapati, learned counsel for the respondent number 4. Accordingly, okay, accordingly, the matter stands adjourned and be listed on 11th of September 2020.
Obliged, my lord.
Lordship, I like to mention item number 26.
Item number
26.
26.
The petitioner counsel is out of station. Lordship, it may be listed in the next week.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed.
My lordship,
And be listed next week. Yes.
lordship, I beg to mention item number 21, lordship.
Item number
21, lordship.
21. Yes.
I need some more time to file rejoinder, lordship. Matter may be listed.
You are for the petitioner.
Lordship, And,
Learned counsel for the petitioner seeks 2 weeks further time to file a reply affidavit to the affidavit in opposition filed by
respondent number 2 and 4.
respondent number 2 and 4.
Obliged.
I'm appearing for respondent number 4 in this item.
Okay, the learned counsel for the respondent number 4 is present.
Obliged.
My lord, I beg to mention item number 20,
20, yes.
on behalf of K lawyer for the petitioner.
On behalf of
K lawyer,
K lawyer, okay.
he is out of station, so matter may
Okay,
list up for 2 weeks.
An adjournment is sought on behalf of K lawyer, learned counsel for the petitioner, that lawyer, Mr. or MS or lawyer is Mr.
K lawyer.
लिखी दी बात, K lawyer, that is personal difficulty of K lawyer. Accordingly, matter stands adjourned and be listed
Lordship, I want to mention,
after 2 weeks.
Lordship, I am to mention item number 35.
35,
Yes,
yes,
I am for respondent 5 and 6.
yes.
I need to,
Have
one
you
big time.
informed the other side?
Yes, I'm for respondent.
No, you are for respondent. Have you informed the other side? Inform him. Inform the counsel for the petitioner.
Yes, I will inform.
You should come after informing. On the prayer of the learned counsel for the respondent number 4, matter stands adjourned and be listed
Yes,
When?
after 1 week.
After a week.
I like mention item number 16.
1-6,
Yes.
yes.
On behalf of the box,
Tapak.
yes. We may be allowed to filing of rejoinder.
Okay, learned counsel for the petitioner prays for and is granted 2 weeks file to 2 weeks time to file reply affidavit to the affidavit in opposition filed by respondent number
Uh,
by the respondents. Okay.
My lord, under items, item number 32.
Item number
32. On behalf of the box.
on behalf of
Standing Council of IOC.
Standing Council of
IOC.
IOCL. A
Uh,
prayer for adjournment is made by the learned Standing Council for IOC. First up, prayer is not being opposed by the petitioners. Accordingly, stem stands allowed. List after
3 weeks.
3 weeks.
My lordship, there is an interim order.
Interim order pass earlier shall continue till the next date of listing.
Let's
May I, your lordship?
Hmm.
Your lordship, I beg to mention item number 4. On behalf of G Talo, for respondent, private respondent number 2.
Item number,
Item number 4. On behalf of G Talo.
where do we get item number 4? Okay, item number 4
Yes, your lordship.
on behalf of,
G Talo, for respondent number 2.
okay. Yes, when?
For 2 weeks, your lordship. After
2
2
weeks.
weeks.
2 weeks. You have taken consent?
Yes,
regards
your
that?
lordship, we have
2 weeks.
already taken consent. Much
For
obliged.
respondent number 4, counsel for the respondent number.
Lordship,
Yes,
may I please mention item number 18? Here, I have to file a rejoinder affidavit. So
okay.
I may be given some more time to file rejoinder affidavit, madam.
You want to file rejoinder?
Rejoinder affidavit.
Item number?
18.
Item number 18, yes. For a petitioner?
Yes, madam.
Petitioner.
My lord,
Reply affidavit petitioner. Yes.
No,
my lord,
sir.
I beg to mention item number 28 and 29, my lord. My lord,
28 and 29, yes.
My lord, I require to file the affidavit, but instruction I have not yet received, my lord. Let this matter be, my lord. This after 4 weeks.
Learned
Standing
Standing Council Education prays for and is granted
4 weeks time, my lord.
4 weeks time to complete his instruction and file affidavit if so advised.
Deeply obliged.
May I please, my lord?
Hmm.
My lord, I beg to mention item number 33,
30, yes.
on behalf of M. Hussain, my lord.
Hmm.
My lord, as per office note, respondent number 6 and 7 awaited, notice awaited.
Okay. Note service report in respect of respondent number
6 and 7, my lord.
6 and 7. Await service report in respect of respondent number 6 and 7 and list this matter after 2 weeks.
Deeply obliged.
Lordship, I beg to mention item number 27.
Yes.
I'm appearing on behalf of Mr. B. Tapo.
Hmm.
Here, we are supposed to file counter affidavit, so 3 weeks' time may be given, your lordship.
For respondent number?
4 and 5, private respondent.
Respondent number, private respondent number 4 and 5. How much time? 2 weeks.
3 weeks.
3 weeks time to file.
My lord, I beg to mention item number 25. My
Yes.
lord, the respondent, the first deputy commissioner, he's retired.
Hmm.
The new deputy commissioner, we have arrayed, that also has been transferred and now new incumbent has joined. I need to file.
Okay, Mr. Attorney Patil, learned counsel for the petitioner submits that he may be granted
1 week.
1 week time to file necessary application for implement.
Implement.
Prayer is allowed, list accordingly.
Obliged, Lordship.
I was, my learned juniors were very apprehensive again if any connectivity issue arises. I am unwell since still I attempted.
It's not fair, my lord. He should have informed me. I should have also gone along with him.
That is what
Very
I
unfair.
proposed. That is what I have
He
proposed
has-
yesterday.
So he has to give me,
I,
he has to
and I
treat me.
thought my learned
He has to
friend
treat
will
me.
be traveling.
He has to
Okay,
treat me.
now your voice is clear today.
Today I am in my office actually.
That's why, because High Court, there is a renovation of, no, because this almost 12, 13 years old system.
Yes.
And it is being renovated, we think by next month, it will be.
Yeah, they are providing connection in my room also, office room also, they have given.
That connections are there.
But
Now test run is also been done.
Test
Now
run
it will
is
be to,
going.
it will be finalized.
another maybe 2 weeks time they.
Maybe within a month.
Yesterday I made my submissions. I'll just clarify 2-3 things.
No, today we are hearing afresh because
My lord.
you argue as per
My
your
lord.
convenience. Because
My lord.
yesterday's situation or
My
something
lord,
different. Can we have this? Can we have some, no, there is already the last. Because I'll have to, I want this here because I'll have to.
my lord, in short, earlier I was transferred once and that transfer was on 21/7/2022.
Can we go, no, can you bring that side? In front of me. Okay, bring, no, no. Remove that.
Return convocation. Return convocation.
But, okay, fine. Yes.
Yes. Well, because of my mother's illness and I am the only member in the family to look after my mother, I came on my personal request.
Click it. Now tell us,
Yes, sir.
what was the earlier transfer?
Well, I'm coming to that, man. Lordship, I've got a small list of this, man. Everything is will be clear. My lordship, may kindly see serial number.
Are you having the record? No.
My lord, record I haven't, my lord.
You have record?
No, my lord.
Okay.
Lordship will kindly see, my lord, on the left hand side, 4/5/2021 is the date. Maybe from top, maybe 5th or
4/5/2021.
Yes. That day, on that day, I was transferred to my home, that is Alo, and that was on my request because my mother was ill.
So this is your hometown?
Yes.
Alo is your hometown?
Yes.
Okay.
Then, my lord, there was some last transfer was on 21/7/2022.
21/7/2022.
And that transfer I challenged in WPC number 264 of 2022. That was in fact disposed of with the direction to dispose of my representation. That was rejected on 24th August 2022. Then I approached this on the court. Writ petition was dismissed. Then October 2022, that date is not there, my lord. I joined after dismissal of the writ petition because initially there was a stay. So I joined
when you joined?
October 2022.
October 2022.
My lord.
Where is your statement? In the writ petition?
In the writ petition, it is there. I'm just giving that statement. Next, also kindly see 22/9/2023. When I filed the writ appeal was allowed. Pursuant to that, my lord, they have passed an order 10/10/2023, and I joined again at Alo 11/10/23 after 1 year. So 1 year I worked in Itanagar, pursuant to the impugned transfer order passed earlier. Then they approached the Honorable Supreme Court. Honorable Supreme Court, as I submitted yesterday, my lord, dismissed the SLP in limine, which is available at page 71. Now
who was the man in earlier round?
Against me, same man.
Then why this other respondent? Who are these other?
This time that in place of that respondent, my lord, the other person is to go. So he will be also, it will be a chain effect, my lord. That is why I have to make.
No, just tell is the earlier man was Yadak Angu.
Yes.
This time also Yadak Angu.
Yes.
And then who are this respondent number 6 and 7?
6 will now go to Yadav Angu's place.
So 6 is the MLA.
6 is the MLA.
And who is 7?
7 is the person who will now go to in place of Yadav Angu, who has been brought in my place.
Now Yadak will be placed where?
In my place, Alo.
In Aro. And
Yes.
what about this Jikren Bagra?
He will come to Alo. I'm sorry, he will go to Itanagar in place of Yadav Angu. So there'll be chain
And
effect.
where will you go?
I will go as respondent number 7's place.
You will go to respondent number 7's place.
Seventh-
Now respondent number 7 will go to your place,
No, respondent number 7 will come to Itanagar.
Itanagar.
Yes.
That post where you were earlier transferred to Itanagar.
I was our transfer.
Earlier you were at
Yes.
Itanagar. Now after joining Itanagar, place is vacant.
Yes.
So you have been transferred to this respondent number 7's place.
Yes. I was in
And respondent number 7 is brought to Itanagar.
Minor.
And this man
From Itanagar to
Itanagar to
in my place.
in your place. Okay.
Now, what I wanted to show to you, Lordship, my Lord, Lordship, may I kindly
What is
turn-
your ground of challenge to this transfer petition?
First ground is, my Lord, there is absolutely no administrative exigency because
Hmm.
just next page, Lordship, can you see page 82? This is the starting point, my Lord.
Page 80.
I have collected these documents through RTI. Page 81 is my RTI application.
Hmm.
And 82 onwards are the documents which they have furnished. So, Lordship, may kindly have a look at page 82.
Hmm.
It says this is by Topin Ete MLA, respondent number 6. This is the suggestion. This is regarding transfer posting of C. Yadav Angu, presently posted as DD, Deputy Director, Elementary Education, Itanagar, to the post of Deputy Director, School Education, West Siang District, in place of present DDSE, Sri Duken Kato, lead petitioner. Sri Duken Kato, DDSE, West Siang District.
So you are still in Alo,
Otherwise,
otherwise in Alo.
yes. Now, Lordship, kindly say, Sri Duken Kato, DDSE, West Siang District may be posted to Nehru Memorial School, Alo, in place of present principal of Nehru Memorial School, Alo, and Sri Jirken Bagra, who may be posted as Deputy Director of Elementary Education, Itanagar. Sub 7 will come to Itanagar. In view of the above, I would like to request the Honorable Minister of Education to kindly do the needful action on the matter at an early date. This, your Lordship, will find down below the date 5/7/2024 within the circle.
Hmm.
This is the proposal. 2 submissions I have to make in respect to this, my lord. This is purely an exertion of influence by the local MLA, and there is, unlike, my lord, the facts in that Masood Ahmed case, where there was some complaint against someone, there is absolutely nothing. Just a suggestion that who should be placed where, which is otherwise the normal function of the administration.
Okay.
Now, this was lying pending since 5/7/2024. The actual exercise of normal routine transfer started from the next page, that is page 83. And there are 4 names. My name doesn't find place anywhere.
Page 83.
Page 83, madam.
This was started when? What is the date of this office note? 15?
Next page also will find the date, 10/5/2024.
Where do you get the date?
Left hand side, page 84, madam.
Page
On top.
84.
Page 84,
10/5.
2024.
Okay.
I'm reading from page 83, madam. May be seen at page 2BC are prayer letters sent by several principals for transfer and posting, which may be seen below. May be seen at deployment list, page 10C, serial number 19, Srimati so-and-so, Principal Malot so-and-so, shall join.
Is the name of the respondent number 6 and 7 or something?
No.
Days were not.
No. Then
That the principal in whose place we have been, he has not made any
No.
request.
Now, Lordship, kindly see page 84. Developments are now taking place. Then note number, next is note number 16. There also my name doesn't find place. Then down below.
No, just tell us, your name does not.
The respondent also, I find 5 is also not there, 7 is also not there.
5 and 7 not there. Okay. Just a minute.
Then, my lord, page 85, note 18, note 19. 19 says,
Note number.
note number 19. Note number 19, the last sentence says, therefore, the file is resubmitted. I'm reading the whole one, my lord. May be seen at page 85, my lord.
Page number 19.
Yes.
Hmm.
Note 19 may be seen at note 15, serial number Sri Chow Enseng Sinkai is principal as so Sepa is coming, and SI number so Takar Mara is principal as so. Therefore, file is resubmitted for further direction, please. Is quite innocuous. Then down below there is one line, file resubmitted after correction. Now these are the corrections. So resubmission is with these corrections. They are also name of none of the persons find place.
Just a minute.
Minor. So in this resubmission also, none of the parties involved in the present transfer order is there. It will go next page. Next page, my lord, note 21 at page 86. Page 19.
Yes.
Thereafter, my lord, this way going on, our names are not there. I can just simply say, my lord, page 87, 88, 89, then 90, up to 93, there is nothing. Then 94, my lord, straight. This is the first time where name of at serial number 3, 4, and 5 who are involved in the present transfer order. 3 serial number.
Who are this?
This serial number 3 is a read petitioner. Page 94, my lord.
94. I was at 93. Okay, page 94.
Yes.
Just a minute. Yes.
It says, as discussed with the higher authorities on 23/7/2024, the transfer and posting of the following DDSC principal has been prepared as under. 1, 2 we can skip. 3 is the read petitioner. He has been now sought to be transferred from DDSC ALO as principal NM GHSS ALO. Number serial number.
Let us see the MLS recommendation, page 82.
Page 82. Just as suggested in page 82. Absolutely ditto, my lord.
Okay. Then where is respondents transfer?
Yes. Serial number 4 and then serial number 5.
Respondent number 5 is serial number 4.
My lord. And 7. 7 is serial number 5.
Okay.
Then next page is slightly relevant, page 95. Serial number 2. Sri Duken Kato DTSC Alo, serial number 3, has also been posted as per HSC order dated so. Now he has only Honorable High Court ordered so. Now he has only 7 months left for retirement on superannuation, that is on February 24. Well, this is an indication by the authority that, see, although under the direction of someone I am doing it, but it's my duty to point out that there was a High Court order earlier, and this man is going to retire in 7 months' time. These things have been indicated. As a transfer order. Thereafter, the transfer order has been issued at page 78. Serial number 1, 2, 3.
70.
78.
Where is the second list? Page 94. How many persons said there? 12.
Page 94.
At page 94.
My lord, yes.
12.
Yes.
So finally, how many transfers were made? 10.
Here 10.
Whom twos are left behind? And what is the reason?
1 and 2. Page 94. Well, serial number 1 and 2 are not there. Serial number 1 and 2 at page 94. Ubi Lombi and Tomi Doke. Their names are not there.
While approving this list, where is the office note? What is the reason? Because ultimately this is the list which has been acted upon except 1 and 2.
Yes.
Is not it?
My
Where is the office note in individual cases approved, not approved? Why this 1 and 2 is approved or the list is as a whole approved? Any office note?
My lord, page 96. Page 96. Page 96, my lord. Note 51.
Note
51 down below, Srimati Pubi Lombi as mentioned in so has joined during March 24 as per HSC order. We may face legal complications if we transfer him out, as it looks like he has not even completed 4 months of posting. Serial number 1, Sri Pubi Lombi's case may be kept in abeyance. Rest from serial number 3 to serial number 12, HCM may approve as proposed. Page 90. 98, my lord, there is one the approval. Page 98. As approved, order attempted and attached here with for perusal and approval, please. এই দুটা নাম মধ্যে এটা নাম বল পুবি রম্বি আর এটা বলছো রমি ঢুকে থাকবো বলবেন
Okay. Yes.
So my submission with your lordship is
Hmm.
here is a case where, well, I'll come to the order passed by the Honorable Court in the writ appeal later on. My submission is there is absolutely no administrative exigency because the authority, the administration never wanted to transfer. There was no proposal. This was lying in the, this request was lying, hovering, and thereafter when the actual exercise started, these started in respect of other officers, but ultimately, abruptly, the name of the, all these 3 persons have come. It is because of the proposal at page 82.
Hmm.
So, my lord, it is purely at the instance of a political person. And secondly, my lord, this is so far as the authority is concerned, this suffers from malice in law because there is no lawful excuse for transferring these few persons. Thirdly, my lord, I would like to show even the transfer policy is very clear. There are 2 transfer policies, one in respect of education department and one general.
Hmm.
I'll show both. Page, lordship may kindly have a look at page 100 first, my lord. It is a general one of 2nd June 1998.
Yes.
1D, lordship may kindly see last but one paragraph. Officers are not to be transferred 1 year before retirement, as it may affect preparation of their pension papers, etc. However, generally officers posted in the field work divisions should be
D.
D, my
Hmm.
1D. Officers are not to be transferred 1 year before retirement, as it may affect preparation of their pension papers, etc. However, generally officers posted in the field work divisions should be posted out to office headquarters 1 year before retirement. And then the 106 lot will find page 106 a specific education transfer policy in respect of the education department, which would apply
106.
106.
Hmm.
And page 107 lot will find there are 2 types of transfers which can be made at serial number 4 types of transfer.
Serial number?
Serial number 4, my lord. Types of transfer. Transfers may be broadly classified into 2 types: administrative transfer, which the department orders suo motu in the exigency of the service and in public interest or on administrative grounds. Second, transfer on request, which shall be effected based on the request of a teacher and eligibility as per the policy. So in this case, it doesn't fall in any of the categories. Secondly, lordship may kindly see page 111, last paragraph, Roman 16, my lord.
Just a minute. Roman 16.
16, the last bottom paragraph, my lord.
Hmm.
Teachers having 24 months or less than that before retirement shall generally not be transferred, though they have completed their 5 years in the same school, as it may otherwise affect the preparation of their pension papers, etc., unless the teacher himself has sought transfer. Now, my lord, this is the background in which the transfer has been made, which shows that it is absolutely vitiated by malice in law and malice in fact as well, because I have made them a party. Now I would like to show the findings of this one, because earlier a similar transfer was made. There was a request. There was no proposal. In a present case also, so far as the administrative department is concerned, there was absolutely no proposal for all these 3 persons. Proposals were in respect of others, and the transfer has been issued. Now, in respect of that, my lord, since the earlier transfer was also on the same lines, this honorable court, while dealing with the same matter in writ appeal, made certain findings which your lord will find at page 63.
Page 60.
3, madam. Para 21. Lordship, will kindly permit me to read para 21 at the bottom, my lord. In the facts of the present case, it is very clear that the initial order of transfer of the appellant was issued citing definite reason, though on the basis of a representation inasmuch as the transfer policy
Where
allows such course. Para 21, my lord, at page 63. That initial lordship is referring here about the initial transfer or because of my mother's illness. The next sentence. However, while issuing the impugned transfer order, the same was done without even any proposal being initiated by the administrative department, and rather the record reflects that the transfer of response number 5 was initiated on the basis of a request by the advisor to the Minister of PWD, inasmuch as such course of action is debarred under the transfer policy. The transfer order impugned is not based on any factor germane for taking recourse to such a course of action. Therefore, in the considered opinion of this court, the impugned transfer order is hit by the principle of malice in law. In view of the aforesaid determination, this court holds that the impugned order of transfer is bad for the reason of being issued in exercise of malafide and arbitrary exercise of power. However, the learned single judge has failed to appreciate such facts and principles of law while refusing to interfere with an impugned order. From the reasons, from the aforesaid facts as discussed above and from the record, it is crystal clear that the proposal of transfer of respondent was initiated on the basis of a request, that is, your note of advisor to the Minister of PWD. The record further reveals that no proposal was in fact initiated by the administrative department relating to the transfer of the appellant. However, suddenly he was transferred only by placing the respondent number 5 in his place, inasmuch as the fact remains that the petitioner was earlier transferred considering his representation and he has not completed the tenure in the said place of posting. In the considered opinion of this court, the office note clearly reveals that the motive of transferring the appellant is nothing but for public purpose of accommodating respondent number 5 as DDAC. Such element of personal bias of the respondent number 6 is writ large from the office notes as discussed here and above. And the respondent number 6 has also not denied such allegation of malafide exercise of power by filing affidavit in opposition. Now, my lord, next page, Lordship, kindly see. Yes, I'm sorry. 24, I'm continuing. We are constrained to hold that the transfer order so far relating to the appellant is concerned, the same was done without any lawful reason, inasmuch as no exigency of service and public interest which led to the such transfer is discernible from the record, except the UO note issued by the advisor to the Minister PWD requesting the transfer of the respondent number 5 as DTAC. Therefore, this court is of the unhesitant view that the impugned transfer is executed by malafide exercise of power and issued without there being any public or exigencies of service. Yet another aspect of the matter is that the transfer policy as discussed here and above was formulated to regulate the transfers of government employee in education department of the state of Andhra Pradesh, which covers all administrative cadres including principal and director, etc. Such policy included the tenure of posting as 5 years and also includes different conditions of transfer, including hard posting, etc. In case of Registrar General, High Court of Madhya Pradesh, I was just trying to refer to the my lordship has already referred. It was held that those such policy of guidelines do not create any enforceable right. However, the employee shall have legitimate expectation for proper implementation of such policy, and that those such legitimate expectation is not by itself is a distinct and enforceable right. However, failure to consider and to give due weightage to it may render the decision to be arbitrary. In the aforesaid, in the considered opinion of this court, in the given facts of the present case, the above decision squarely covers the controversy at hand, inasmuch as the appellant was transferred and posted after giving due weightage to his request, including his date of superannuation. However, while transferring back as reflected in the record, no consideration under the transfer policy was made, nor any exigency of services are discernible for such exercise of power, and therefore such exercise of power is nothing but an arbitrary exercise of power. The Honorable Apex Court in the case of Poonam Verma, reported in 2007, 13 SSC 154, also had expressed the view that
Transfer judgments are not so long. Sometimes,
my lord,
sometimes it
this
does not
matter was heard on 2-3 occasions before the Honorable Court number 1, my lord, if Lordship recalls. Well, my submission before Lordship, I have got another submission. My lord, when a particular type of exercise undertaken for transferring a person has been dealt with earlier by the Honorable Court, and this Honorable Court has disapproved the same, and the matter was taken to the Honorable Supreme Court, and Honorable Supreme Court by an order by in limine dismissed by one line. And both the parties were present, I'm told, my lord. I subsequently came to know about the lawyers who represented. Our side was represented possibly by Honorable Justice B.K. Sharma, now practicing. So on the first day, we had some jokes also. What I'm suggesting to your lordships, my lord, when the same exercise has been disapproved by the Honorable Court by clearly recording a finding that there is no administrative exigency, number one, it is malafide, number two, it is against the transfer policy. And now you do the same thing, that shows that you have got no regard for the order passed by the Honorable Court. That is another disturbing factor which I want to point out, my lord. Otherwise, lordship may say, other side may say that you are still in ALO. This gentleman respondent who wanted to be brought in my place, if he really is interested in going to ALO, could have been given to the other place where I am given. But why in my place? To show that arrogance is there. No, earlier this court has struck down, we will do it again, we will redo it. But this is not permissible under the law, my lord. My lord, I'm trying to draw an analogy which may not be directly applicable. There is a law which says that, my lord, decisions of, my lord, court. Lordship may kindly have a look at this, my lord. My lord, page, lordship may kindly straightway turn to. This is
Which paragraphs?
2023 SCC online for my
No,
learned
paragraph,
friend website. SCC online, Supreme Court 1137, NHPC Limited versus State of Himachal
Paragraphs?
Pradesh. Paragraph, my lord, this is page number 34, Roman 37.
34.
Roman 37. Page number 2. Page.
Page number two.
Page
Relevant
number
page?
is 29. What we will find on top, my lord, after the first line, page numbers are given.
1129. 11?
Page number is 29. ma'am. On top, my lord, SCC online web edition, etc. written. Next
Okay,
line
page
starts with page
20,
number
29.
29. Para 7, relying on other judgments also are there, my lord.
3.7, okay?
7. The consistent thread that runs through all decisions of the court is that the legislature cannot directly overrule the decision or make a direction as not binding on it, but has power to make the decision ineffective by removing the basis on which the decision was rendered. Consistent with the law of the Constitution, and the legislature must have competence to do the same. And what I'm trying to suggest by showing the judgment is, my lord,
Understand?
My
They
lord,
want to say, take a different route to what has been done to
Yeah.
undo. This is your
Yes.
argument.
And I'm trying to draw it analogy, but this case is directly not applicable, man. Let me be very clear. It is about legislation. If some law has been struck down by the Honorable Court, subsequently by amendment or otherwise, they cannot act against the judgment, but they can remove the foundation of the judgment and they can pass a fresh law. This is the law. So here what they are doing is, they are redoing the same thing to ensure that what the process which was undertaken and disapproved by the Honorable Court, we will redo it. This is my humble submission before the Lordship.
Yes.
And my lord, one more aspect. After your lordship yesterday passed an order, and it was open in the open court, it was dictated. Thereafter, they have issued an order. No, I'm not doing this before.
Yes, state.
My lord, this transfer, present transfer method, it is quite different from the other method. The earlier transfer, it was there's a station transfer in respect of petitioner man. But here in the present case, man, there's no station transfer within the allow only. That's shifting of the office table only, my lord. The same location allow, my lord. Same town, my lord. And such transfer, my lord, it cannot be strictly said, it cannot be said to be transfer. It is not a transfer, my lord. It's an internal arrangement in respect of petitioner because he has been accommodated in the same place only, same town, man. There's no change of town, station, my lord. So in such cases, my lord, as my lord's aware, my lord, even a single day, it can be done, my lord, even for just within the same station, my lord.
So
Even
that we understand, but
my
what
lord,
do you
reason
say
is not.
what do you say about argument and file noting? You address on that. That we understand. This is the same location. There is a change of school only. Now that argument he has made referring to the office note, what do you say and relatable to the judgment?
My lord,
of the earlier judgment between the two persons, same place of posting, earlier judgments and certain findings.
My lord,
And he is arguing that see, similar procedure has been followed.
my lord,
Earlier it was PWD minister, now it is local MLA, and that is how it is proceeded from day one. These three persons' names were not there. Subsequently, this name has come.
my lord, that,
And exactly as the proposal made by the local MLA. What
My
to
lord,
say on that?
my lord, that is, my
Don't
lord,
smile. Smile says many things.
my lord, my
Don't
lord,
smile.
my lord, my lord, my humble submission, my lord.
Yeah.
Although it has been shown, my lord, this you are not, my lord, but in the file noting, my lord, this has never been taken into account, my lord. There's no noting in the file noting. There's no reflection about the you are not, my lord. We cannot say that this has been taken into on basis of this has been done, my lord, because there's no reflection. Had it been the case that the authority, while issuing, they have specifically mentioned that there is a request from the concerned MLA to accommodate these person, and if this scenario, if this the account was the fact was brought on the record, madam, then that could be a different thing. But in the present case, madam, there's no such mention in the file noting, so it cannot be said that this has been done on the basis of the file noting, my lord. And that is why, my lord, although in
And
the,
what do you say about the note while putting forward by the officer or clerk whatsoever,
yes, my lord.
bringing to your notice that he is having only 6 months, 7 months to retire?
My lord, that is there, my lord.
It's very urgent. It seems.
My lord, that part, my lord, since it is,
There must be something on record to
My
say
lord.
that yes, though he is 6 months, but in view of
yes,
the
my lord.
urgency or whatsoever, but that we cannot consider. Anything is there on the record?
My lord, on the record,
No
my
doubt,
lord,
no
that
doubt.
is,
This is transfer policy is not mandatory.
my lord,
Is that it?
my lord, my lord.
It's not mandatory. That even if it is within 6 months, your transfer policy itself says he can be transferred.
My lord,
But however, that note was brought to the notice of the higher authorities. Just see, he is by virtue of an earlier High Court's order, he is here. Okay, forget about the High Court's order. If facts are different, forget
Yes.
about High Court's order. Now he is to retire within 7 months. Have you considered that?
my lord, that fact, although it's been, is not initiated, but this has not been taken into account, my lord. And while issuing, my lord, that has not been reflected.
So
How?
whether that has been dealt or not, because
Madam,
the
that
division
is-
bench says that he will have a legitimate expectation to have consideration of his grievance under to implement the transfer policy, and in violation of that decision may be different.
My lord,
But violation of legislative legitimate expectation in terms of the transfer policy is an arbitrariness.
my lord.
Any arbitrariness transfer can be interpreted. This is the division bench judgment. Now that we'll have to address it. Forget about others. We are forget about the facts, the ratio laid down. It says that yes, there are specific observation in this judgment, saying that yes, transfer policies will not create any right upon the persons. However, he must have a legitimate expectation that state will apply. This is somewhere written.
My
State
lord,
will apply the policies. Now that policy that there is a bar is not an absolute bar. We are time and again saying that there is a not will even we not say there is a recommendation in the policy itself that or there is a policy itself that a person should not be transferred when it is his service is less than 1 year. So that policy was brought to the higher authorities. Now, what did higher authority do? We are not saying the higher authority is bound to follow. We are not saying.
my lord,
But what the higher authority did, we want to know it from you. Mr. Das will not know that.
my lord,
Because he is nobody to this. He is only he has been transferred.
my lord,
Yes.
that is maybe the reason, my lord, that he has been posted in the only shifting of the office, my lord. He has not been posted out of this
So
station. my lord.
according to you, this is not a transfer.
My
By
lord.
the way, what is the meaning of a transfer? What is the definition of a transfer?
My lord, it is,
Change in the place of posting. Okay, your argument is that that policy is not be affected because he is in the same place. And the purpose of such policy is to give the pension papers.
my lord,
This is your argument. Okay.
that,
Anything to be added?
my lord, That is because his transfer, there's no station transfer within the place only.
What
And that can,
urgency? You could have waited for 7 months, post will be vacant.
my lord,
Only 7 months.
maybe my lord, in the place where he has been accommodated as a principal, yes, his service is urgently he required, my lord.
Urgently.
That's
required.
because he's a senior.
Don't smile, I'm telling
My lord,
you,
he's-
don't smile.
My lord, I'm told he's senior, my lord, and good in administration, my lord. That's why, my lord,
We understand,
good,
you are very efficient, you want the good administrators to be in the right place.
my lord. That's
Last
why,
time also, this was the same argument.
my lord, that's why, my lord.
Yes, Mr. Das. Mr. Das.
Yes, my lord. May I please your lordship? I think I'm clear. Voice is clear. I'm clear, audible.
You are audible, but your video is fixed. Anyway, now yes, yes.
Yes.
Now,
Now, my lord, the concern of the court is about the UA note. That's what I've
No,
understood.
not yet, not yet. We are not concerned with anything right till now.
No,
We
no,
are
what
just
is,
hearing the
what,
argument.
no, what is, no. That's what your lordship has put a query. Concern means your lordship has put a query on the UA note. So UA note has
He has
been.
answered it. He has answered it. He
No.
said that there is no mention of the way note, and this is a proposal along with you. 12 many names were concerned, so there is no nexus between the way note and the transfer.
I just want to show the UA note. That's very, very important, which my learned friend, Mr. Dilip Bozundar, has shown the UA note.
Okay. Okay. Where is paragraph?
My lord, page
Page
82.
68.
Kindly. No, please see 82
Page,
first.
page
82.
68.
82. 82. 82
Yes. Huh.
is the representation which is by an MLA has written that there is a representation made by Yadak Angu to post of so and so. This is the first which my learned friend has shown. Correct, my lord, if I am not wrong. This is the first. Page 82. Now kindly see. Yes. And my learned friend has shown the note from 83 to 86. Now, if you see 83, 83 is note number 15. Note number 15 is transfer and posting of principal / DDSE. Lordship got it?
Okay.
This is posting
Yes, got
of
it.
both principal and DDSE. So my learned friend said that all this by neither the petitioner nor the respondent's name doesn't appear in this note number 15. Note number 15. Nobody's name appears. Now, if you please turn, then your lordship has put a query, where is the date? Then that's 84, it is reflected 10/5/2024. That at page 84, 10/5/2024. That's the date. Note of 15 is the date of 10/5/2024. Now, 85, my learned friend has shown note number 19. Note number 19 may be seen at note number 15. Now, therefore, the file is resubmitted for further direction, please. So again is resubmitted for further direction, please. Now kindly see down below, file resubmitted on bottom, file resubmitted after correction.
Okay, file resubmit. Okay.
After correction. Now please turn to page 86. Now, if your lordship kindly see, this is the corrected of the note number 15, but here it reflects what I have seen. The following principles have so far as submitted application for a transfer, posting as shown under. I have not seen anything of the DSC. Is only principles. But if your lordship kindly see at serial number 3, so and so to DDSE Namsai district, DDSE. But in the top, because my lord, DDSE and principal are these equivalent post. Now, note number 22. Kindly see note number 22 down below.
Yeah.
Now, note number 21, submitted for perusal and decision of the higher authority, please. At page 86, after this note number 21, submitted for perusal and decision of the higher authority, please. Lordship got
No,
it?
no, next note number 22 says on the bottom of
21.
this page,
No,
uh,
21. 21.
the following
After
principles
serial
are so
number,
far.
after serial number 4, submitted for perusal and decision of the higher authority.
This
please.
is a higher authority, please.
Yes, this is 22/5/2024. Now, if you see note number 22, please put up with all other representation received. That means there was some all representation received from the
Okay.
principal VPs. So on 26/5/2024. Now,
What is VPs?
VPs, vice principals.
Okay.
Vice principals.
Okay.
Now, page 87, note number 25. The following principal DDSE have so far submitted application for their transfer posting as under. So these are the list who has submitted their, because they stated that all other representation. So these are the list which has been submitted.
So this is 9 people, total 9.
9 people. 9 people.
Okay.
Now, my lord, kindly see at page 88. Therefore, at page 88, if you see, therefore, the file is submitted for perusal and revision of the higher authority, please. Lordship got it?
Yes.
Now, note numbers 26, kindly you see. This is regarding transfer and posting of DDSC and principal. It is to mention here DPC for promotion for headmaster, principal, vice principal to the post of principal was held on 10/6/2024. But the meeting was deferred owing to some administrative reasons. Next DPC meeting may be held very shortly. Kindly see next page. Therefore, transfer and posting may be done after DPC at one go instead of piecemeal basis. Now, 27, note number 27. May like to see notes above. The transfer and posting of following DDSE was effected by memo number so and so with the approval of Honorable Minister Education, order placed at 20C. So these were the names, 5 names. My lord will kindly see at page 90. Now kindly see at 7. 7 principal have submitted representation for their transfer and posting again vacancy which reflected note number 25. In this regard, it will mention DPC promotion from headmaster, vice principal likely to be held soon. Therefore, if authority deems appropriate, transfer posting of principal may be considered after DPC. Now, page 91. Now 91 from 30 to 32, my lord. If you see, kindly see, please discuss
91 from 32.
31, 32. That means internal discussion. We may discuss tomorrow at 3 p.m. Note number 30, as discussed today, may like to endorse the file for decision of the competent authority, please. No, it's in person. 92. If you see note number 34, next page, 92. Honorable Minister Education may be apprised. It is advisable. It may be if matter may be discussed in person along with Secretary Education. Now, note number 36, agreed as suggested by Commissioner. Now see note number 38. Secretary Education may like to come with details of all the DDSEs, all the DDSE posted in the district, attest at headquarters and any other place. At note number 38, my lord, this is important. See note number 38.
Yes.
Secretary Education may like to come with details of all the DDSEs posted in the district, attest at headquarters or any other place. All the DDSE. Now, 40, note 40, print out all the documents and submit to me in hard copy for further submission to higher authority, please. At note number 40. Now, 93, note number 42. No, this is not required. Now come to 94.
94.
Now kindly see 94, note number 44. As discussed, so there is some deliberation as discussed with the higher authorities on 23/7/2024, transfer and posting of following DDSE principle has been prepared as under. So some deliberation was made with the higher authorities. There is no question of MLA coming. Here the authority has decided as discussed with the higher authorities. So and so posting of following DDSA has been prepared. Now, your lordship, I don't want to repeat, your lordship knows 3, 4 and 5. 3, 4 and 5. Now, from the above, now kindly see down. From the above, 12 principal DDSC in the case of Pubi Lambi and Duken Katu are as under. Now, my lord, 1, Pubi Lambi has rejoined as DDSC so and so during March as per Honorable Supreme Court's order. Duken Katu Alo has also been posted as per Honorable High Court's order. Now he has only 7 months left retirement on superannuation so and so. Here, file is submitted for kind perusal and decision of the higher author. So what I understand from here, my lord, 2 things are there. Both has gone to Supreme Court against an order passed by division bench by this honorable court, by the High Court. Because there was a transfer order, both has been transferred. And both, if you see, because I'll show this Pubi Lambi judgment as your lordship judgment, that's division bench judgment of this court, it was against an order of learned single judge, whereby both was transferred. Now that was aggrieved, and the respective parties were before the learned single judge. Learned single judge did not interfere with the transfer order. Now both this was the division bench, it was moved, and if I am not wrong, please correct me, both the matter was heard by division bench together on the same day. On the same day, separate judgment was passed by this court, and both the judgment, what I understand, was interfered by division bench. And ultimately, both consist of UA note. Both consist of UA note. I'll show it. Both consist of UA note, and it was interfered only on the basis of UA note. Today also, what I understand from the query that has been made and by the argument by Dilip Mazumdar is on the basis of UA note. What is the ground of the UA note? Absolutely no administrative exigency, what I understand. So on what basis a UA note? How a transfer can be made? What is the value of an UA note? That's what is on, my lord. Now, if you see both the judgments which was interfered by division bench was 2 grounds. One is UA note and one is over a circular, on a circular. Now, if your lordships looks into the order passed by division bench, which my learned friend has just placed before this court about division bench judgment from page 45. Now, lordship don't have to see. I'll just point out the paragraph 21 has been read, 23, 25 has been read, and 26 has been read. 26 and 22 has been read by my learned friend. So, if you see para 22, it is on the basis of request UA note of the advice of Minister of PWD. Now, if you see, in this case also, after that, after the litigation was over, there was a request which was made at page 82. Request has been made by the minister, by the MLA. Request was made.
Local MLA.
Local MLA request was made. So, I think this here also at page 64, paragraph 22 was initiated on the basis of a request, UA note of the advisor to the Minister of PWD. So this is the whole crust of the matter. Both was interfered by the court, went to Supreme Court. In my matter, what I understand, it is not moved by Honorable Justice B.K. Sharma in my case. In another case, that matter was moved by Honorable Justice B.K. Sharma as a lawyer representing her. And both the matter came in two different courts. Now, in our case, my lord, in before, unfortunately or fortunately, it was dismissed in limine. So they doesn't want to exercise their power under 136. Because we don't want to exercise our power under 136, so they dismissed in limine. In another case, Lombi, where your lordship was interfered, that case also, but that was leave to appeal was granted, and it was discussed in detail. Discussed in detail. Today, the argument which is advanced is not.
Where is the judgment? Where is the leave is granted?
That's why I'll tell your lordship, this is not circumventing your lordship's order. We have greatest respect to the order passed by division bench. Also, we have greatest respect to order passed by any order passed by Supreme Court.
No, these are not issues. If the principle laid down,
yes. Now,
laid down
yes.
is same.
Correct.
This has been interfered The subsequent
Right,
dismissal in limine is nothing to be taken note of.
No,
That
no,
is a
right,
simple
right.
proposition
No,
of
your
law.
lordship
So,
is-
so as
your
the,
lord-
let us not go to that. So as the judgment.
So-
If that judgment is sub
Now,
principle is
my lord,
overruled, that is
no, no,
overruled.
1 second, 1 second. 2024 SCC online SC
Anybody
279.
assisting you here?
Yes, 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 I have all, listen. We already are, it's already handed over. 2024, my lord.
I have read this judgment. I'll read it for once for you.
Now, my lord, kindly see. 1 minute if lordship got it. My lord, I will trouble your lordship with paragraph 2 first, my lord. Please see into the facts, paragraph 2. Kindly bear for a moment, my lord, paragraph 2.
No, no, where is the determination by the Supreme
No,
Court?
no, my lord will kindly see para 2 first. My lord,
Huh?
kindly
Para two,
bear,
yes.
no, kindly
Yes.
bear it for a moment. See para 2, last 4, learned single judge by upholding order of transfer dated, observe transfer made on basis of UA note dated so and so put up by the member of legislative assembly so and so itself cannot be held to vitiate the transfer until there is an allegation of malafide extra part by respondent issuing the order. Lordship, right? Now, please kindly see paragraph 4. Paragraph 4. On next page. Paragraph 4. On filing writ appeal. Paragraph 4. On filing writ appeal by respondent number 5. Division bench of High Court, while setting aside the order of learned single judge, observed that UA note of MLA was approved without application of mine, and any remark of admissive exigency by department to substantiate that it was in the public interest or in exigency of the service, the relevant excerpt of the impugned judgment read as under. Now, this was the observation 27. The appellant who was already under order of transfer is having a legitimate expectation to join and continue transfer place of posting. However, his transfer order was suddenly modified without any proposal being mooted by his employer by acting on the proposal local MLA and his favor of respondent number 9. In the above backdrop, this court is of the concerned opinion such transfer is neither issued in the executive service nor in the public interest. Rather, the same is result of arbitrary exercise of power. Now, kindly see 29, last 4 line. In the last 4 of 29, your observation of 29, this court cannot approve such kind of, lordship got it? 29.
Yes.
This court cannot
Yes.
approve such kind of sheerly lackluster administrative procedure adopted in the decision-making process in as a proper administration under the constitutional scheme of governance. Every state action must be supported by reason. In the present case, the fact cannot be ignored. Appellant was already under order of transfer and he was released on 19/4. He joined at the place of transfer and thereafter in the present case further necessary to have the decision input supported by reason in cancelling the earlier transfer order. That too when the proposal transfer response initiated not by the administrative department in public interest or the executive service. Rather, it was purely on the basis of UA note given by local MLA. Therefore, in the considered opinion of this court, the impugned order cannot be said to be an order or transfer in public interest on executive service. The judgment, now my lord, questioned before Supreme Court. The judgment of division bench has been questioned before us. Inter alia, containing a matter of transfer scope of judicial review is limited only when such transfer is in violation of statutory provision or due to malafide reason. As a corollary, it is not open to the court to interfere with the order of transfer on a post which is transferable. In absence of any malafide alleged or infraction of any professed norm, if such transfer is not detrimental. Further, it was canvassed that a transfer on the instance of MP-MLA always would per se vitiate the order of transfer. Now, argument by the number 6. Per contra, learned counsel appearing for respondent 5, who was writ petition before the High Court, submitted malafide is of two kinds. One malice in fact and a second malice in law. In the peculiar facts of case, division bench has rightly set aside the order which do not warrant interference. Conversely, learned counsel state has supported the content appellant and urged such consideration of UA note of MLA modified order of transfer has been passed in public interest after due application of mine, and division bench has committed an error in setting aside a well-reasoned judgment on learned single judge. Paragraph 8 onwards, my lord, all the judgment of the Supreme Court, skip this, all the judgment up to paragraph 15.
Come to 15, paragraph 15, 16.
15, 16. Now
Yes,
15.
yes.
In view of the foregoing annotation of the law by judicial decision of this court, it is clear that the absence of pleading regarding malafide, non-joining the person against whom allegations are made, violation of any statutory provision, allegation of transfer being detrimental to the employee who is holding a transferable post, judicial interference is not warranted. In the sequel of the said settled norm, scope of judicial review is not permissible by court in exercising of the jurisdiction article 226. 60 finding. 16. On examining the facts of the present case, it is apparent that respondent 5 herein was transferred from the government higher secondary school so and so to Leopard as deputy director of so and so by order dated 15/11/2022 and was directed to join in the last part of April 2023. The UA note dated 28/2020 has been written by the MLA specifying the administrative agency and public interest posting the appellant in the post of DDSC so and so. The said UA note has been examined and competent authority exercise discretion in favor of the appellant. Respondent 5 herein has been retained on the same post in the same district, same status, which was holding prior to order of transfer, unaffecting his salary. Besides, it is also averred by the state modified order dated 24/2023 was passed prior to effective period during which respondent was directed to join, that is the last part of April 2023. Now paragraph 18. In view of the stand taken by government in the absence of the plea of malafide and no averment regarding violation of statutory provision taken by private respondent before the High Court, interference as made by division bench, setting aside the well-reasoned judgment of the learned single judge, is not justified merely on unsubstantiated text that a proposed modification arbitrary or without application of mind for the sole reason that it was mooted by the MLA. In our view, the division bench has committed an error and so and so, so and so. So now, my lord, here a difference is that had been at page 82, there was a representation which was filed and that was a note was there. But if you see the entire note, it was not through an MLA. It is much more better. In the administrative exigency, it has been decided to transfer. Now, if you see his whole ground before this court and in the representation, if you see, my lord, at page 79, second representation, kindly see.
At page?
My lord, transfer order is page 78. Page 76, kindly be seen, my lord. 72, my lord. 72. Before the impugn order, 72.
Yes, 72.
At page 74.
74.
Yes. It is representation of the petitioner at page 74. It may be mentioned, it may be noted at Roman 8. It may be noted under an already written representation letter dated to the commission with humble request not to transfer from a present place of posting and to comply with direction of the Honorable Guwahati, but to the utter shock and surprise, Office of Commissioner has totally failed to consider my representation. Rather, considering all the representation and also failed to comply, transfer set for norms, guidelines, and rules. Now, that has not. Now, see, in view of the above, I request to intervene and give necessary direction to concerned Officer of Education Department not to transfer me out of my hometown at the fact end of my career when the period left for supervision is only 1 year and 2 months. Date of supervision, so my mother. Now this, my lord, kindly see 75. Considering the facts, I fervently please to intervene in the 75 current ongoing attempt for transferring me out of my current place of this order is 19/12/2022. That is prior to all this UNO, prior to this UNO. Now 77 also he makes a representation, similar representation. Thereafter at 78 this transfer order has been made at 78. So now it appears that the petitioner has been kept in Alo. He has not been transferred. He has been kept in Alo. Is only what my learned friend government advocate said. It is only a place of, is a posting, shifting of the tables. He has been retained in Alo. Now, the ground which he has mentioned in the writ petition, if you see, now kindly see at page 22 of the writ petition. My lord will kindly see page 22, paragraph 29.
Yes.
See, the 4 lines, 20. The petitioner humbly
Page,
begs to say that
paragraph.
29.
Yes.
The petitioner prima facie case, the petitioner humbly submits that at present he is residing in government accommodation in Alo. However, the impune transfer order is given effect, he will have to vacate such accommodation. The same will put the petitioner's family to immense hardship. Petitioner has not yet handed over charge of DDC, hence the balance of convenience is in favor of so and so. Now, there is one judgment of the Supreme Court is regarding about the UA note. 2010, just your lordship can note down, 2010 4 SCC page 192. We have given the copy para 34, 35 and 36. 34 and 35 is important. We have already, I think, handed over the copy. Your lordship kindly look into that judgment. 34 kindly see. 34 kindly see, my lord. Lordship got the copy?
Yes.
It is tried to say, while exercising, Lordship got page 208. It is tried to say that while exercising power of judicial review, the superior court should not readily accept the charge of so and so laid down against the said and is functioning. Burden to prove the charge of malafide is always on the person who moves the court for invalidation of the action of the state or its agency and instrumentality on the ground. Same is vitiated due to malafide, and the court should resist the temptation of drawing dubious inferences of malafide or bad faith on the basis of vague and bold allegation or inchoate pleadings. In such cases, wisdom would depend that the court should insist upon furnishing some tangible evidence by the petitioner in support of his or her allegation. 35. It must always be remembered that in a democratic polity like ours, function of the government is carried out by different individuals at different levels. The issued and policy matter which are required to be decided by the government are dealt with by several functionaries, some of whom may record notings on the files favoring a particular person or group of person. Someone may suggest a particular item action which may not be conducive to public interest, and other may suggest adoption of a different mode in larger public interest. However, the final decision is required to be taken by designated authority keeping in view the larger public interest. Noting recorded in the files cannot be made basis for recording a finding, and ultimate decision taken by the government is tainted by malafide or influenced by extraordinary circumstances.
This is the basically mute point.
Yes,
Moot
that's
point is paragraph 35.
absolutely, my lord. That's the point.
Yes.
And my lord, only one thing I just want to place it before your lordship, if your lordship kind consideration, that what is doctrine of merger, if suppose it is not being decided by the
No,
episcopal.
no, that is not necessary as did. I have accepted that
Yes.
even SLP is dismissed.
Right, right.
You can seek a review in the High Court without Supreme Court's observation. Our full bench decision is there.
Right. And thus
If in a single point a ratio, we are bound by the ratio of the Supreme Court, not by the ratio of a division bench. Now
Correct.
distinction will made in a later stage. Now today we are considering
My lord,
about
yes,
the interim order.
interim order.
That's
No, that's my submission before your lordship.
Okay.
My lord. Yes, I am deeply obliged.
Yes.
Two things I'll show.
My learned friend cheated me. He has gone.
Next time I'll allow.
Reasons not to be disclosed.
My lord, two things I'm rather
If
completely.
somebody can have all the benefits sitting in his chamber, why will he come?
And maybe
Maybe better benefits.
and
No.
smile, my lord, smile, etc.
Yes.
indicative of everything. My lord, two things I would like to show, my lord. The case of Pubi Lombi is slightly different. That was a case of modification of a transfer order subsequently, and under what circumstances, para 16 is clearly written. So factually, it's different from two angles. One is this.
No, factually different,
Two,
but ratio has been laid down so far relating to touching the issue of the OM, or office note and how it is to be dealt. Of course, facts are different. You
My
are
lord.
trying to relate the action, malafide action, continuing malafide action.
Exactly.
This is your case.
Yes, and in
His case is, see, there is no mention of way note in any of the notes as regards transfer. In earlier cases, everywhere, in fact, in these cases also, according to me, in some cases, MLA's note are taken note of. But in your case, it is not taken note of. It is a regular transfer, therefore it should not be
Yes.
done.
my lord,
Now, so far relating to the other argument, 6 months, their argument is that, okay, you are.
Same place.
It is same place. This
Well,
is the basically for the purpose of
yes,
interim order.
yes, just
For purpose of detailed hearing, for merit,
Right.
of course, many things will come, whether that judgment will be binding in the given facts of the present case, where the judgment passed by this division bench, which is relatable to the between the same parties,
yes.
will be a binding precedent, or the other one will be binding
Absolutely
precedent.
not, my lord.
That
So
will-
still now they have not asked for any modification, assuming that there was
So
some.
therefore, that will be, they
Yes.
should need the further deliberation.
My lord,
Okay.
even otherwise, my lord, in that judgment, there is in paragraph 18, it is clearly mentioned, in view of the stand taken by the government and in absence of plea of malafide, we have taken a plea of malafide there. There was no plea of malafide because I am aware of that because both the cases were heard together before the court number 1, my lord. My learned friend Mr. K. N. Chaudhary was appearing. His only case was this kind of modification cannot be done. That was the basis. In our case, it was a case of malafide because there was no proposal. Lordship has clearly held. These things are not there in this case, my lord. So there are distinguishable facts are there, my lord. Number one. Number two, my lord, in our case, very, my lord, disturbing fact is, Lordship, kindly, I'm just pointing out. Page, Lordship, kindly have a look at page 95 and 96. After this list was given at page 94, in respect of two persons, Lordship has seen there is a deviation. Now, page 95, Lordship, kindly see this difficulty arising, which may arise, complications which may arise in respect of execution of the transfer or proposal, whatever it is. Pobilambi is indicated there is a Supreme Court order. Duken Kato is indicated there is a High Court order. Now, Lordship, kindly see the next page, page 96, note 51. It says, so far as Pobilambi is concerned, complications may arise.
That we have
But-
said, page 95.
Page 90, yes, page 95 is the indication by the officer. Let's see, there are litigations and he is going to retire in 6 months' time. These are the factors which the authority has to take into consideration. This is the file noting. Page 96, bottom, my lord, says, note number 51, serial number Pobilombi as mentioned in note 44 has joined during March 24 as per HSC order. We may face legal complication if we transfer him out as it looks like he has not even completed 4 months. Pobilombi's case may be kept in abeyance. So since there is a Supreme Court order, High Court order we can ignore. This is the view of the authority then. Supreme Court's order is there, so there may be some complication. High Court order is there, so you can ignore it.
Okay, I will pass this order because we have given you
My lord,
more than what is required.
deeply outlined.
So
And deeply
therefore,
obliged.
we'll pass this order, we'll get the order uploaded, but this will be a notice and we'll consider the interim. We'll get that.
Absolutely.
My lord, deeply obliged.
Deeply obliged.
Well, according to first impression, according to this court, we need to go through the record. Whether we may issue a notice or fix it, any preferable date if we issue notice or fix it.
21st.
3rd of September, my lord.
3rd of September.
My learned
Second-
friend may have an advantage because of other case, but I don't have that advantage.
No.
3rd of September.
Dilip,
Third.
if it is not inconvenient to Mr. Dilip Mazumdar and this court on 2nd, let it be on 2nd. You come for
Correct.
1 day ahead. Second.
No, 3rd I said because 3rd is a Tuesday, my lord.
No, that will be a problem. Second, there is some matter.
Second of September.
Second. I'm deeply obliged.
In the meantime, lawfully, I'll pay for an interim protection.
Definitely
Well,
consider. We'll
I'm
consider,
Minor,
let
minor.
us apply our mind sitting in the
I'll-
chamber.
Absolutely.
He will come say, he will definitely pray for interim. I will say object.
That's the case. So ultimate decision,
my lord,
ultimate
and-
decision.
and
See,
that's the
if I
part-
dictate this order,
no,
either way it will
no,
take,
no,
if I reject this
Lordship,
interim
I-
order also, I'll have to give a reason,
My-
maybe 2 paragraphs. If I,
Lordship may at your lordship convenience pass. We have no taken. We will possibly smilingly accept the order.
yes,
Yes, yes. And Dilip has to treat me for treating me.
Absolutely.
yes, next.
I'm
case,
deeply
next
obliged.
case.
I'm
Keep
deeply
it in
obliged.
chamber.
It's very
Deeply
nice
obliged.
to argue against my land tender. Then I must open this here.
Deeply obliged.
Item number? Yes, tell us.
Your Lordship, the petitioners here are the villagers of Gandhigram,
Here,
located in Vijayanagar Circle.
then what is
The
the
Department of Land Management has issued a notification for the
Then
land acquisition under section 11 and 14 of Land Rehabilitation
compensation.
Settlement Act.
what is your grievance then?
My grievances is that, sir, or Your Honor, the petitioners have not been given a equal opportunity to of hearing, and their name is not. They have not given opportunity of hearing to include their name in the draft list of the land compensation affected area.
This is under what?
Your Honor.
Notice was issued when?
Notice was issued on 7 to 2014.
And what is the period of notice?
It was 15 days,
Then you did not furnish, furnish reply.
Your Lordship.
Why then what can we help with?
Lordship, it was supposed to be published in at least in the two daily newspapers, and the location, it is far from the main Meow. It's more than 150 kilometers location.
So it
There
was
is no
published
proper
where it must be published in the office of the collector and all.
Yes.
We'll issue a notice at this stage, nothing more. Nothing more. Petitioners who are residents of Gandhigram village in the Birjaynagar area of Sanglang districts has, how many petitioners? Have
50,
filed the
50.
present writ petition assailing that no proper notice was there under section 11(1), read with section 41 of the right to fair compensation and transparency in loan acquisition, rehabilitation and resettlement act 2013, and therefore they could not participate in the could not file their objection in the said process, being villagers of a very remote place where there is even no newspaper circulation. So, and according to them, for such wrong procedure adopted, they are being deprived of the land acquisition compensation. Full stop. Issue notice returnable on given date. After 4 weeks. 13th of September 2024. Notice was just mentioned.
Most obliged, Lordship. Wait, please, Lordship.
Yes.
On Lordship, I have filed a writ petition 321 on the 8th. It was moved on 9.
Then there,
Yeah. Only the basic issue was that had the entire 17 posts been regularized then in terms of the government policy, I would have been regularized.
that we have issued some notice.
Notice-
Some,
notice-
which case?
Well, now the Public Service Commission has advertised those 9 posts, which include the post which I am claiming, Malad. Now that was published on 11th of this month. So, Malad, at this stage, my prayer will be that to take with this along with that earlier writ petition, and in the meantime, at least one post should not be filled up till the disposal of
You
the.
participate in the
No,
selection.
but, we are not disqualified. I'm already 46 years old. The maximum is 30, 33, 35. That also is a big issue. my lord.
How many people then Darren will may open the floodgate? Okay,
My lord,
where is the repetition? Earlier repetition?
earlier petitions, my lord, it is in the registry. My lord, I have not called for.
Do you remember?
321, my lord. My lord, I have annexed that the
Order, where is that?
page 10, my lord.
The petitioner is a dental surgeon and was recruited on contractual basis after due selection process. It is the case of the petitioner that similarly situated persons were regularized against sanctioned vacancies in terms of extent norms and policies and rules of the government. However, the case of the petitioner was not considered even though there was a vacant post.
Yes.
Full stop. In the aforesaid backdrop, the petitioner filed WPC 321 of 2024. Full stop. This court, under its order dated 9/8/2024, issued notice in the said petition. Full stop. The present writ petition is filed assailing an advertisement dated. Where is that advertisement dated 8th of August 2024, whereby the Arunachal Pradesh Public Service Commission had invited online application for filling up of 55 posts of General Duty Medical Officer GDMO under the Department of Health and Family Welfare,
Which
Full stop.
included nine posts of dental surgeon.
which includes 9 posts of dental surgeons.
And my lord, amongst these nine posts, the
Full
post which was
Full stop.
vacant due
It
to.
is also case of the petitioner that the post against which the petitioner was expecting his regularization has also been included in the advertisement. Full stop. Accordingly, this matter needs further consideration. Accordingly, let a notice be issued. Let a notice be issued, returnable on given date.
My lord, as per this newspaper, last date of receipt of application is 29/8/2024.
List this,
But
list
no
this-
date has been fixed for the examination.
List this matter on 2nd of September or
My
12th of
lord,
September.
that will be after the result.
Maybe we'll protect you for the time being. We'll not stall the process. Let them proceed with the process. Just
Yes,
keep
my lord.
one pen post should not be filled up without leave of this. That's all.
Yes, my lord.
They let them proceed. Returnable on 12th of September 2024. Full stop. Considering the nature of grievance, more particularly the assertion that the petitioner was appointed after due selection process by the state, and the state is having a policy of regularization of such persons who had duly been selected, this court in the interval, not this court, considering as an interim measure, it is provided that though the APSC may proceed with the advertisement dated 8th of August 2024. However, a post of what is call it?
Dental surgeon.
Post of dental surgeon.
GDMO within bracket dental.
A post of GDMO within bracket dental surgeon shall not be filled up without leave of this court. Full stop. উপরত notice
This may be taken with
notice. Swenso upon he is accept notice accepted by whom? Please give us who appears for whom. No formal notice is required.
No.
No private. No. Give who appears for whom. Just take note.
My lord, this may
But we
be.
have a doubt. Moment we pass this, many people will in the queue.
My lord, this may be
Therefore, we have said proceed. Once the door is open, many will come and say, please keep a post vacant for us also.
Well, this may be taken along with the WPC number
Hardly
321
letter along with WPC 340.
321 of 2024.
We were not a party. We are not a party.
In that earlier this thing, matlab, here that's why I have filed a writ petition. Otherwise, I would have filed a IA because here I have made the
Oh, in that you are not a party because that was not there. Here is party.
yes.
Okay, then it's fine. Yes. Only that much you proceed. One more copies. Copies, extra copies they will give. All extra copies. Yes, next.
Now I'm giving it to Oblige.
Just give who access for whom. Please give.
Item number 1.
Item number. No, item number 1. What is it? Item number 1. Yes.
Yes.
Yes, corrected cost criteria.
Yes, Your Honor.
You have done it.
Yes.
Okay. But office note 88. Okay, thereafter you have done it. Hart, Mr.
A Bodo.
A Borough Learned Council for it. Will issue notice?
Yes.
Hart on A Borough Learned Council for the petitioner. Also Hard MS so and so for respondent numbers 124 and you are for 3.
Respondent number 3.
3.
Yes.
Only 4 respondents?
Only 4.
Huh? It's okay. Hmm. You don't have any case. It cannot be anyway. The petitioner is aggrieved by an order dated 28th of February 2024 passed by the 2024 passed by the Commissioner, Department of Agriculture, Government of Arunachal Pradesh, whereby the prayer of appointment of the petitioner under special relaxation given to the Purolik/Sulung community has been rejected. Issue notice returnable after 4 weeks. So accepts notice on behalf of respondent number 1, 2, and 4. So accepts notice on behalf of respondent number 3. As parties are duly represented, no formal notice need be issued. First of, however, extra copies of the petition, requisite in numbers be furnished to the Learned Council for the parties within a period of 5 days from today.
Right.
Item number 2.
Yes, affidavit filed.
Yes, we have served.
Anybody
copies.
appears? Bank? Yes,
I'm representing respondent number 1 only.
bank.
Yes, bank.
What you say?
I filed the backlog number only this morning only.
Okay, now what do you say?
Uh,
Any instruction from the bank?
I may be given some time.
No,
Okay.
understand, but we have issued you a notice for the reason so that she's seeking for what is the present status? What is your instruction from the bank?
Your Lordship, I've not updated with the present status.
You have given only the wakalatnama.
Yes.
Now, why? What is the need of you being here at before issuance of notice? We have asked the bank so that they can assist us. She's saying that I am ready and willing to pay this much of amount. Please do not
Disposes.
do not dispose me. We have not even issued notice. Yes, you are appearing for whom?
Same. For respondent number 1 only.
Then we'll stay.
Yes, the branch manager of Nijuli branch.
Nijuli branch.
Yes. It's the
Branch
bank.
manager of Nijuli branch will not do. Who is the other
Even
respondent?
this rest, they said they serve also, we have served. Madam.
Have you filed affidavit?
Yes, madam. We have
Where is the
filed.
affidavit?
Yes, we got it.
Okay, when you have well, today morning,
Yes, madam.
you could have given a sleep.
Sleep given already.
Please bring the affidavit. We'll take after some time. You have instruction. You ask the higher authorities in the bank that they want to give deposit an amount and with a request that they want to have us one-time settlement, please do not dispossess us from this property. Okay, so if you do not have any instruction, we will pass that order. We have issued the notice for that purpose. This bank is so casual, then we'll pass this order. You have your instruction, telephonic instruction. You have given the copy of the writ petition also?
Yes, yes, ma'am.
Huh?
Yes. ma'am.
Yes, next case.
Next-
After some time, go and have a consult on instruction from your client. And ask the branch manager to have instruction from the higher authorities at Guwahati.
And second case also we have served.
Same,
notice.
same. Both. Second also same.
Yes, yes.
You have instruction. 2 and 3. I will take after the other matters, yes. Yes, what is your instruction?
This I will point out 2, 3 clauses, my
Yes.
lord. Actually, my lord, after e-procurement, the bidder used to submit their tender documents through online, and after filing through DSC, that is digital signature, author certifying that these are all original documents.
Where is it? Show us the provision.
Yes, my lord. From this here only I am showing, my lord.
Page,
Page 49, my lord,
page 49,
clause 13.
page 39, clause 13.
13.
If the information given.
49, my lord.
39,
49, my lord.
page 49,
Page 49.
clause
13, my lord. If the information given by the tenderer in the tender document and its annexures and appendices is found to be false, incorrect, or has breached any terms and conditions of the contract at any stage, Food Corporation of India shall have the right to disqualify, summarily terminate the contract, forfeit the EMD as the BG, make good any other.
Yes, what is the meaning of this?
Yes, then after 60, my lord.
Yes.
Page 60, my lord. Their forwarding letter.
Page,
Like your lordship queries was that after the technical bid, if we qualify, then documents need to be verified.
verified.
So, my lord, in e-procurement, they uploaded the documents, my lord, and
So
on the
understand,
basis of that,
see, what will be the clicking point of the contract? That is the issue. Not the issue that you have power to do this or you have power to do this. You show us
On
the
the-
clicking point of the contract is deemed
my
to
lord,
be executed.
on the basis of these clauses and their undertaking, my lord, I page 60, my lord,
Page
60,
60.
60, my lord, of the WPC. This is the forwarding letter to the general manager number 1.
Yes, page 60. Yes.
This is the forwarding letter of the one of the bidder, I mean the petitioner only, to the general manager. I submit the e-tender appointment as road transport contractor. I have thoroughly examined and understood all the terms and conditions. Then, my lord, clause 5 is important, relevant here. I do hereby declare that the entries made in the tender and appendices, annexes attached therein are true, and also that we shall be bound by the act of my or duly constituted attorney, my lord. Then at page 61, I certify
Page
61. Next page, my lord. The last paragraph. I certify that all the information furnished by me is correct and true, and in the event that the information is found to be incorrect, the Food Corporation of India shall have the right to disqualify me or without giving any notice or reason thereof, or summarily terminate the contract without prejudice to any other rights that the corporation may have and under the law. Now, my lord, as per the clause 80, while issuing the letter of acceptance, my lord, we have, by the forwarding letter also, we have asked him to furnish all the papers which were uploaded.
Not the issue. It is not your case that your documents are false, therefore you have terminated.
Yes, ma'am.
Is it your case?
No, this is not my
This
case.
is not your case.
Because he has not furnished the.
Understand?
Yes.
Understand. It is not your case. Your case is that contract has started, you have rescinded from the contract,
Yes, ma'am.
therefore it is
Therefore, we have-
terminated.
there-
So
there-
therefore, so any of the terms under the contract which suggests that this is the starting point of the contract, because admittedly here no contract was signed.
My lord, this MTF, the FCI is.
What you do, what is your practice is none of our business. Our business is to look into the documents and to have a satisfaction. Here basic point is that you have done the action against him for violation of the terms of the contracts, and you have, according to you have terminated the contract. His question is that contract was not entered. Where is the question of giving this liability and things? So as the clicking point of contract, either will go in his favor or your favor.
The petitioner case is that, first of all, they resile it before, at the time of.
Result
resigning,
from what?
That they are unable to provide the security deposit because of. their
Understand? So
financial
as a thing,
That-
a security deposit is a part of the contract.
Yes,
On
ma'am.
the moment when you say, you have two propositions. One is that you will have to upload the documents in the e-portal, and successful bidder will have to give the document to you, tender document.
First of all, my lord,
Ah.
technically, if they are technically qualified, then their price bid will be open.
Open, yes.
And price bid has been open,
I'm
and
saying
L1 has been given this letter of acceptance.
No,
As
no,
per-
no. What you have done, we are not for the time being interested. What we are interest is to come into a definitive conclusion to understand what is the procedure prescribed under the tender document. As per the tender document, procedure is this, subject to if you argue something different, that there will be a technical bid evaluation. After technical bid, price bid will be open. And thereafter, the tender documents is to be signed in the hard paper downloaded, which has been issued. And thereafter, after verification, you will issue him the letter of acceptance. Now, on last occasion, issue was that admittedly there is no signing of contract, not the signing of hard copy of the tender, except uploading. So
Signed
whether,
copy- Signed copy of the tender document
was not there.
Then there was uploaded. It is there, my lord.
Where?
In every page of the tender document, my lord.
No, this is the
It's not
uploaded
hard copy.
document.
Yes, uploaded document.
Where is the clause?
My lord,
Yes,
close.
so let us go to the
My
clause
lord,
again.
Page 48, my lord.
Let us see the procedure.
Before the place, clause 8, my lord. Submission of tenders, my lord. My lord, kindly for a moment, my lord. B onwards, my lord. Before coming to the main clause, my lord. All the supporting documents, except tender documents, have to be scanned and uploaded in technical bid, price bid, as per Appendix 8, provided at para B, has to be scanned, encrypted, and uploaded at the requisite place in the e-procurement system. My lord, C, my lord, kindly see. All the annexer and appendices of the MTF duly signed on each page by the tenderer should be scanned and uploaded. my
No, that is
lord.
that.
Only, my lord, signing is required by law, only the annexers and the appendices of the MTF, my lord. And what the E says,
See,
my lord.
therefore, E said, kindly see,
Yes,
Mr.
ma'am,
Singh.
therefore E says, ma'am.
Mr. Singh,
Yes, my lord.
what you say, manual bids, hard copy of the tender will not be accepted. First stage is you will have to upload. However, the successful tenderer will have to submit the original hard copy of the MTF duly signed on each page of the MTF along with annexer appendix duly attested on or before date and time stipulated by the FCI. Failing which the EMD of the bidder is liable to be forfeited, and further the award of the contract through the letter of acceptance will be issued to successful tenderer. So
only after he
so
fulfills.
until and unless he gives the hard copy sign,
I have got this point, my lord. My
hard point, then you can, what you can do is you can forfeit his EMD, nothing more, nothing less,
Yes.
and give it to others. In your case, without that document, you have issued him a LOI. He said, I'm not interested, therefore I have not even submitted. How can you issue like forfeit my EMD?
But he being a MSME, there was no EMD.
No EMD, so it will
So
go.
now, my lord, to discourage his contract has.
No, this you have not provided anything for this kind of MSMEs. Matter ends there. And the clauses you relied on reflects that if subsequently, even after signing of documents, it is found that your documents were incorrect, that they can cancel the contract. Here contract is not even signed. So dictate this order. That's all.
That 7-4, my lord, page 47.
Yes, so
Clause 7-4, security deposit.
this
Page
matters to-
47.
Huh?
Page
Page-
47, down below Roman 4. In the event of the tenderer's failure after communication of acceptance of the tender by the corporation to furnish requisite deposit under.
No, acceptance will come later on.
My guess
You
is that,
cannot force a person to accept because he has resigned from the contract by not signing the document in terms of E.
Now, when he has resigned after he was,
No, see, you have not even notified him a date that please give us. Before notifying a date, how can you issue an LOI?
And my lord, in the LOI
No,
itself,
after-
my lord,
after
says
he
that,
was-
my lord, at page
after he was
75,
found,
the letter of
found he
appointment
was
to the
LOI.
contractor will be issued only after fulfilling the requirement and confirmation of bank guarantee. These instructions are.
That is bank guarantee will come second stage.
Yes, my lord.
When you accept this contract. That's all. Hard. Mr. R. Saikya, learned counsel for the petitioner. I have also heard Mr. Singh, learned counsel representing Food Corporation of India. Full stop. The present writ petition is filed assailing the decision of the respondent authorities to execute the work to execute the road transport contract, okay, EX/RH, all capital slash FSD Bhalukpung to FSD Bomdila on regular basis at the risk and cost of the petitioners. Full stop. The basic ground of such challenge is that the respondent authorities could not have put the risk and cost upon the petitioner when the petitioner prior to petitioner did not proceed with the earlier tender process and did not submit the documents in terms of clause 8 within bracket E of the earlier tender and therefore according to the learned counsel for the petitioner, no contract was executed between the petitioner and the respondent FCI. Therefore, they are not within their jurisdiction to invoke clause number. Which was your clause? Huh?
No, invoke, my lord, 9, my lord.
No, that risk and cost.
risk and cost, my lord, 7-4, and then again,
No, you have interest risk cost.
and 9E.
7-4, my lord.
In terms of clause 7-4 for the earlier tender. Full stop. Per contra, Mr. Singh, learned standing counsel for the FCI, submits that though in terms of clause clause 8 within bracket E of the of the tender document, the petitioner did not submit the manual with hard copy of the tender document. However, he is not within its he could not have resiled from the contract after issuance of letter of intent. We call it letter of intent.
Letter of acceptance.
letter of acceptance of the contract. And therefore, such refusal to accept letter of acceptance and execute the work entails him to penalty as has been done by the authorities. Full stop. In this regard, Mr. Singh places reliance on the clause 13 of the tender document to argue that the genuineness of the documents can be verified by the FCI at any stage, and therefore clause 7, clause 8 within bracket E is not a mandatory clause, inasmuch as the petitioner had, while submitting his e-tender, had made a declaration that all the documents are correct. Full stop. Therefore, clause 8 within bracket E is not a mandatory clause, and therefore all meaning and purport when the petitioner was declared to be a valid tenderer and his tenderer, it was his bounden duty to execute the contract which the petitioner has resiled, and therefore he is liable to make loss good to the FCI. Full stop. We have considered the arguments advanced by the learned counsel for the parties. Before adverting to the arguments advanced by the learned counsel for the parties, let this court first record the factual aspect of the present case. Full stop. The petitioner is an entrepreneur registered under MSME within bracket micro, small and medium enterprise. Full stop. The FCI floated an e-tender via e-tender number C, page 10, paragraph 4, green mark. Okay. Dated 17/6/2021 for same work, na? Same work.
My lord,
Work is same.
its work is same.
For road transport contract XRH/FSD Bhalukpur to FSD Bomdila on regular basis. Full stop. Page 6, cost title, green underline. Pursuant to the tender process, the petitioner participated pursuant to the advertisement, not tender process, pursuant to the said advertisement, the petitioner participated in the tender process. Full stop. Initially, he was declared to be technically eligible, and thereafter his price bid was opened. Full stop. He being the L1, a letter of acceptance was issued. However, the petitioner did not accept to execute such work, and in the aforesaid backdrop, the FCI is to issue a fresh tender for the same work, and therefore they have fashioned the liability of the new tender process at the risk of cost of the terminated contract. Prior to that, when petitioner did not accept it, thereafter, it is to be noted that when the petitioner did not respond to the letter of acceptance the contract was terminated by the FCI. Full stop. Then this is over. Full stop. The basic arguments and counter arguments of the parties are that the basic argument of the not the counter, the basic argument of the Claret counsel for the petitioner that the contract was not even entered between the parties, and therefore in terms of the tender document, the petitioner was within the right not to accept the letter of acceptance, and on that occasion the only penalty that could have been imposed by the FCI to forfeit the EMD. Full stop. They had no sanction and authority under the terms of the tender to execute the work at the risk and cost of the petitioner. Full stop. On the other hand, the fundamental argument on behalf of the FCI is that the respondent that moment the tender price bid of the petitioner was accepted and the petitioner had uploaded the tender documents in the e-portal after signing, it is deemed that the contract was executed, and therefore they are within their right to execute the work at the risk and cost of the petitioner on his failure to execute the contract. Full stop. He further submits that petitioner being an MSME, there was no EMD, and therefore the FCI is also not in a position to recover any EMD from the petitioner, and having no alternative, the work was decided to be executed afresh at the risk and cost of the petitioner. Full stop. In the aforesaid backdrop, now let us consider the terms and conditions of the tender documents. The relevant provisions are, first relevant provisions is the clause 6, which prescribes deposit of earnest money at the rate of 2% of the whole value of the contract to be submitted electronically along with the bid documents. However, there was an exception that MSME enterprises need not deposit such earnest money. Clause 8 deals with submission of tenders. In terms of subclause A, B, and C prescribes and mandates the documents and appendixes which are required to be uploaded in the e-tender process. Full stop. Subclause E prescribes that tender is to be uploaded through e-procurement at the designated web portal. Full stop. It is further mandates that manual bid / hard copy of the tender document will not be accepted. The said process further prescribes that the successful tenderer will have to submit the original hard copy of MTF. Manual, what is MTF?
Model tender form.
Have to submit the tender document duly signed on each page along with annexer appendixes duly attested on or before the date and time stipulated by the FCI. It is also mandated that on failure of the tenderer to submit such document, the EMD furnished by the bidder shall be forfeited, and the FCI shall be at liberty to award the contract through the letter of acceptance. No. So, it further provides that the FCI that FCI can award contract through a letter of acceptance only after fulfilling the requirement envisaged at clause 8 within bracket E. Clause 8 within bracket 3. In the case in hand, it is an admitted position that the FCI, after the completion of the tender process, did not notify any date or time for submission of hard copy / manual bid signed and certified by the bidder. Full stop. It is also an admitted position that the bidder also did not insisted to go ahead with such submission. However, at that stage, the letter of acceptance was issued, which the petitioner refused to accept on the ground that the petitioner has decided not to execute the work. Therefore, in that background and under the clause 8 within bracket E, on the admitted background that there was no procedure was finalized or completed as regards submission of signed copies of hard copy of the tender, it cannot be said that the contract was initiated. Even it is assumed that letter of acceptance is the result of submission of the hard copy of the tender document, and there is no necessity of signing a separate contract, then also signing of contract did not happen in this case. Therefore, there was no contract on the date when the letter of acceptance was issued to the petitioner, inasmuch as subclause E of clause 8 bars the FCI to issue a letter of acceptance without fulfillment of the condition that a hard copy duly signed is furnished to the FCI. That being the position, in the considered opinion of this court, the FCI could not have executed the work at the risk and cost of the petitioner, inasmuch as petitioner had not become a contractor by that time, and his status was only a bidder. Now, dealing with the argument of Mr. Singh that in terms of clause 13, the signing of hard copy of the contract is not mandatory, this court is not inclined to accept such argument, taking note of the language of clause 13 of the contract.
I have not stated it mandatory, but at the latter stage, it can be.
Mandatory.
It is.
Nor this
it is
court
at any
is,
stage.
nor this court is in agreement with his argument that such mandate given under clause 8 within bracket 3 is a curable defect and can be executed at the later point of time. More particularly, for the reason that clause 13 prescribes that if at a later point of time it is found that the documents, annexures, and information given by the contractor / tenderer the Food Corporation of India shall have liberty to disqualify and summarily terminate the contract, forfeit the EMD, security deposit and bank guarantee. Full stop. In the considered opinion of this court, clause 13 only declares a right of the FCI to terminate the contract in the event certain wrong facts are submitted or wrong documents are submitted, and it cannot be relatable to a signing of the contract and under clause 8 within brackets subclause E. Full stop. That being the position. So yet another aspect of the method, the clause 16, another method, the terms and condition governing the contract under clause Roman 9 prescribes that the security deposit is to be submitted within 15 days of acceptance of his tender. 50 days of his tenders. And on the failure of such on a failure, contract is liable to be summarily terminated besides the forfeiture of the earnest money. Full stop. However, as held herein above, in the case in hand, without signing of the hard copy of the tender document, no contract in fact was executed, and therefore such clause is also cannot be made applicable in the present case, inasmuch as the present case. Accordingly, the present repetition stands allowed by by setting aside the clause that the contract executed pursuant to NIT dated 25/1/2022 cannot be executed at the risk and cost of the earlier cost of the petitioner. However, the FCI shall be at liberty to approach appropriate forum for recovery of damages for the conduct of the petitioner, if so advised and if permissible under law before appropriate forum. Since you don't have EMD, that you will have to feel the damages. Yes.
By quantifying the damages, madam.
Huh?
By quantifying the damages.
Yes, obviously.
Yes, next.
Oh, earlier, please.
How many matters are there? Okay, we'll come back at 2.
Sorry, my lord, due to unavailable circumstances, my lord, I am mentioning, my lord, item number 22, my lord.
Item number
22, my lord.
82.
22, 2, my lord.
The difficulty is on last occasion also, my lord, I personally, my lord, requested the counsel for the other party. My lord, difficulty is, my lord, I've taken the building permission, everything's, my lord. Now my construction is being stopped, my lord. Though there is a operation of
And at that matter, if he wants time, what to do, tell us.
My lord, only that
No, don't go to the merit. First, let us
My lord
know
may had
which is an adjournment.
my lord may had heard him today, my lord, and my lord may heard me on
See,
day after
today
tomorrow.
is 14th. When I will hear it, him, keep it part heard, then I go back, I come back, I take a judgment from here to Guwahati. This is not possible. That's why we fix it. If it could have been possible, we have dictated in the court.
my lord, only 5 minutes.
Don't say only, no 5 minutes. We'll have to see,
Well,
lawyers are very in an advantageous position. They can argue whatever they like, give the points, both sides, and the decision is to be made by us. We'll have to give reason why this is so, why this is not so.
On-
1 hour, Mr. Das and Mojumdar has argued,
My lord.
isn't it? Now I'll have to pass the order.
On Monday, my lord.
Monday.
Monday. I have today.
Monday. Now he'll have no urgency. Monday we'll have no urgency. Till Friday he's urgency, having urgency, isn't it? We know that. Now he'll say in the month of September without a date. Isn't it?
Well,
Tell us. We know urgency is till Friday.
Today, my lord, I have some
Yes,
complaint.
understand, we'll adjourn it. Just give us a date. Let us not waste time. No date.
my lord,
On the
Fri-
prayer of the
on
learned.
Friday, my lord.
Let's say Friday. On the prayer of the
Monday, my lord.
learned, Monday?
My lord.
Not Monday.
Monday, my lord.
Monday. Okay. On as agreed to by the learned council for the parties, list this matter on Monday.
My lord.
See, only issue is to be determined which will prevail. That's all, and subsequent without notice. Yes, that's all. Okay, next case.
My lord.
My lordship.
Hmm.
Lordship, I would like to mention item number 36, lordship, supplementary hearing. Lordship, I am mentioning on behalf of G. Talo, lordship, private respondent number 6. Item number 36.
Jitalo, yes.
G. Talo. Private respondent number 8.
Who is for the petition?
I have taken the consent.
When tell us. Yes,
After-
the senior council is also there. You are for? Okay, when?
My lord, it is otherwise with the consent of it was fixed today, my lord. In that case, my lord, if there's difficulty, my lord, that today after 2 weeks, my lord.
After 2 weeks. After 2 weeks, as agreed to.
And my lord, just further what mentioned, my lord, at number 17 and 23, my lord. My lord, I've taken consent from the other party also.
17 and
23, my lord.
23.
Yes, can this be listed after 4 weeks, my lord? 4 weeks, my lord.
Lordship, item number 17, I am the petitioner, Lordship.
Everybody wants to go.
There is
go
a
home. Item
status
number?
17, Lordship.
Interim order.
Yes,
There is interim order.
Lordship.
Interim order pass earlier shall continue in item number 70 till the next list of listing.
Obliged.
Yes, you finish the list.
Yes, Lordship, I want to mention item 6 and 7.
Item
6 and 7.
6 and 7 not yet completed.
Yes. Lordship, I need 1 week to discuss with the petitioner because I received one.
File the affidavit, Your Lordship, as per last order, Your Lordship.
Yes,
Okay.
Lordship, I received the affidavit on
Okay, it
yesterday.
is submitted that the pursuant to earliest order dated
8/8.
8/8/2024. The state has filed their affidavit, isn't it?
Yes, Your
Full
Lordship.
stop. The learned counsel for the petitioner submits that he may be granted. Yes, how much?
1 week, Lordship.
1 week time to file reply. Full stop.
Lordship.
Okay.
Prayer is allowed, please this matter next week.
This
After-
affidavit, Your Lordship, was to record the approval, land approval of that only, Your Lordship, not
Okay, that's-
affidavit.
No, no, not. Therefore, he said in terms of the earlier order.
Yes, yes.
Oh.
Okay.
Much obliged.
So it's a case of dismissal after affidavit. Isn't it? Now it's a case of dismissal after the affidavit. That's why we asked the specific point. You file this affidavit, she has filed matter as there. Anyway, adjourn. Item number? Yes, Ricky.
My lord, the matter has become infructuous.
Infructuous.
Yes, they've been in the meantime promoted.
Okay, Mr. Panging, learned counsel for the petitioner submits that in view of subsequent promotion of the petitioner as they claim comma, the matter has become infructuous. Accordingly, matter stands closed. Close to bar.
Problem.
Being infructuous, yes. Last items. Hmm? Yes, where is the
My lord,
bank?
it's not there. Actually, he spoke to me.
What is it?
He wants some time. He doesn't have any instruction. And they are
Now,
not
do you
able-
think that there will be disposition immediately during pendency?
No, on 8th, the recovery officer has passed some order. He is saying that since the matter, they have filed a writ petition. So they have not passed any specific order on disposition.
I do not think they will pass, and it's very difficult for us also to pass a stay order that. we will
I
not-
understand
not-
the
not-
limitation of this code.
Very
I understand.
limited. So notice will suffice, I think. So we'll record that they need to want an obstruction. So we'll fix this matter.
If
On-
they want to take any possession, they, at least the leave of the court should be taken. At least they should be cautious that Lordship said.
Full stop. So you're issuing a notice.
And my lord, may I specify that they, while filing the affidavit, they should give a statement of accounts. There's some anomalies. I'll point out later.
Okay, we'll see that. We'll
Fine.
just click off. Third, MSP Chakraborty, learned counsel for the petitioners. The first paragraph of this order dated 7/8/2021. 2, full stop. 2, 1 and 2. Then third paragraph will be a little bit different. In the aforesaid backdrop, though an interim order was pressed by the learned counsel for the petitioner, this court think it prudent to hear the bank before hear the bank, full stop. Accordingly, the petitioner was directed to serve extra copies of the writ petition upon respondent number 1 and 2, intimating that the matter is fixed for consideration today and interim prayer also be considered on that day. Full stop. And a direction was issued to the petitioners to file affidavit in proof of such service. The petitioner has filed affidavit in proof of service. This court is satisfied that notice was duly served upon the respondents as regards the pendency of the writ petition as well as order dated 7/8/2024. Full stop. Though two learned counsels, what were the names? We do not know young counsels. Names. Learned counsels had entered appearance on behalf of the bank. How though they have appeared, Ms. Learned so and so and has entered appearance on behalf of respondent number 1 and 2. However, they candidly submit that they are without any instruction from their client. That being the position, matter was fixed in the post-lunch session. However, none appears for the respondent bank. Full stop. The learned MSP Chakraborty submits that the said learned counsel has intimated her that they require some more time to obtain instruction. Full stop. Be that as it may, as none appears for the petitioner, full stop. Let let a notice be issued to the respondents returnable on give a date for 18th of yes, Madam Papia.
Can it be 20th?
28th of September 2024. Full stop. Petitioner to take steps upon the respondents to register court with AD as well as through regular process. Full stop. In addition, the petitioner is also permitted to take steps through Dusty service, However, so and so, full stop. Considering the nature of grievance and the willingness of the petitioner to settle the dispute when can you deposit this amount?
50 lakhs.
Because that was the basic condition that if you deposit, will pass an interim order. Or will issue a note. Because it will make it difficult, harder difficult. Full stop. Let a notice on interim prayer also be issued, returnable on the same date. Full stop. Both the same order, huh?
20 lakhs. He has already paid 20 lakhs now, along with this OTS proposal. At a check of 20 lakhs, he has already forwarded. So that
It is also submitted that the petitioner has already started paying their
he has
outstanding dues and an amount of rupees
20
20.
lakhs by way of check, he has forwarded to the bank.
20, and in the first case, in the second case,
Second case, we have not paid
20,
anything.
no, let us not say all this, not necessary. Okay,
Yeah.
same order in the same case, but look into the amount and things are different in the other prerogative.
Not any position that may be they
Okay,
contradict.
so any
Yes.
position, any coercive action taken shall be subject to outcome of this.
My lord, with the permission, with the leave of this court, my lord.
No, there is that order we cannot pass until unless you say that, see, predicament, until unless you say that we will deposit this amount.
20 lakhs.
So
we are
therefore,
depositing
we are
in the first case.
issuing a notice. We know that since they have not done anything, they will not do anything. A petitioner is permitted to make a mention for listing if any coercive action is taken in the during till within the returnable date. Make a mention, we'll see on that. Okay. Yes.
24 affidavit and reply is ready, but the petitioner has some health issues. Needs some more time.
Okay. Mr. Panging, learned counsel for the petitioner submits that though reply affidavit is ready, however, it may some time to file the same. So accordingly, he prays for some time. Prayer is allowed, please this matter.
But after 2 weeks, I will.
After 2 weeks, any interim order?
Yes.
Interim order pass earlier shall continue till then.
Okay.
Yes, what is this 30 and 31?
My lord, file the affidavit in contempt petition, my lord. This,
yes, what is your stand?
my lord, what happened, my lord, is like this alleged contemners, my lord. And the misapprehension, by there is a status quo order, but it is a restraining order was there, my lord. But it started construction. Already they were in the possession of
That's why I was saying specific that whether you have made construction, if you have an explanation and if you are saying that we are not proceeding with the construction.
not on that day itself from there, my lord, not taking.
Okay,
This
file
even in the
file a
report
response to it. Okay.
Not accept.
If he's saying that not yet constructed, then we'll decide this contempt on the next day.
My-
Or in fact, we'll decide the writ petition itself.
Yes,
My-
page 25, they have admitted that they have started construction.
But they are saying that this is not willful. We are under misconception.
My lord.
That, see, contempt is always, it should be willful. So even in government's case also, so we'll see, today we cannot decide that they are contempt. And even if we say that there is contempt, we'll have to issue a further notice for punishment. This will take some time and we'll have to give a reasoned order. So contempt is quasi-criminal.
Quasi-criminal.
Therefore, okay, an affidavit has been filed by the alleged contemporary in terms of discourse order dated. In terms of discourse order dated 12/8/2024. Full stop. The learned counsel for the petitioner may respond to such affidavit. Full stop. Accordingly, matters stands adjourned and be listed on listed after 2 weeks.
Much
You are not well, somebody made a mention or something like that.
my lord.
You are not well or what? Somebody said, or not you.
No,
Okay. Okay. Yes.
Obliged.
None appears for a petitioner on call. No name is also reflect in the no name of the council also reflected in the cost title. Accordingly, registry to list this matter again after 2 weeks, reflecting the name of the learned counsel for the petitioner. Okay, name is not shown. Okay.